Hey everybody, it is Christine Burke with Help Solve the Case, and thanks for being here. We are reviewing Chapter 6 in the book Broken Plea by Christopher Whitcomb, the retired FBI agent, and he has been discussing a whole heck of a lot. This chapter appears to be focused on the statements made by Dylan Mortensen, okay, one of the surviving victims from the house, okay? Now, not that I want to skip anything, but it's very important to understand what he's written here in this chapter, okay? And it goes to how we analyze cases. So here's what Christopher Whitcomb. So this chapter is entitled, and I urge you to get the book because I can't even do it justice. No play on words here, but there's just so much in here. And I appreciate y'all coming along. So this chapter 6, is entitled "The Vampire Diaries, Burke, and the Black Balaclava." Okay, which is AKA ski mask. Now, Christopher Whitcomb, the author, starts off this chapter saying, "Whatever happened inside 1122 King Road at 4 o'clock Sunday morning, only one survivor is known to have come face to face with the killer. According to widely scrutinized reports, Dylan Mortensen, a 19-year-old University of Idaho sophomore, was standing in the doorway to her second-floor bedroom when a masked intruder, later determined by police to be Bryan Kohberger, passed within inches." Okay, and he says, widely scrutinized reports, okay, because I think what he's saying here, he hasn't spoken to her. I don't know if she's done any public interviews, okay? So everything's coming from the police reports. And I'm debating here about this chapter for a reason, because this chapter appears to just be a regurgitation of the report. And the key part of the report here is, it says, although the interview was recorded and we will excerpt transcripts later, police saw fit to file supplemental 0003 paraphrasing statements. So this portion of this entire chapter appears to be a transcript, a verbatim writing of those reports. And we have those reports. And the note here is that it's paraphrased. It's paraphrased. So remember when we were talking about in the very beginning about how reports, and Mr. Whitcomb pointed it out too, how reports are written and people don't review their body cam footage. And I went into length about how I don't agree with it, that I believe, being an old dog, that the reports need to be written the same way that the officers on the scene need to remember stuff and do stuff just like we did back in the old days, because something could happen to the recording. And because the fact that we don't have time to read reports and go back and watch video and all that stuff. It needs to be done the right time. Now, with respect to paraphrasing is there for a reason. It gives you a gist of what happened. It's paraphrasing. It's not verbatim. And so my thought is, if we can read a transcript of the interview, I assume we have it because Whitcomb's talking about, we're gonna go through portions of it. Why would I read all this stuff when it's a paraphrase? I want the actual details. Because I don't want to think something and not get the actual. And this is the report. She said, she said. It's not it's not to my understanding, okay, because it says she described, she advised, she explained. They're not saying, because she said this, I did this. So I would rather hear it from the horse's mouth, okay? I think I don't want to say it's a waste of time, but it's not going to do us any good. Let me go to the last, well, I'll just mention it. So Christopher Whitcomb, right, he wrote all that out. It's pages and pages and pages. And he says Dylan was interviewed 4 times between Bethany's 911 call and Bryan Kohberger's change of plea hearing. He also mentions that this information that was obtained from her does not include grand jury testimony she provided in May of 2023. So she apparently testified before the grand jury. Grand jury proceedings are usually secret. He notes all but 2 initial accounts were made in the presence of her lawyer, but only the grand jury statements were made under oath. And under oath is a sworn statement, means you can be impeached with it, okay? Formally, perjury. You can still kind of be impeached when you get on the stand and the attorney makes mincemeat out of you. Well, didn't you say here? They just make you look stupid, okay? So the point here that he's making, which we're going to go back to the transcripts, he says, for the parts that he, the cop, feels are important, okay? That's what I'm saying. We're not going to just blah, 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 this. He says, Whitcomb says, she never verified or corroborated details of what she claimed to have witnessed that fateful Sunday morning. Okay, so I ask you, whose responsibility is that? I believe that's the cop's responsibility to verify whether a witness is being truthful or not. Now, I'm not saying she's lying, but people can be under the influence. People can have trauma, like they could be knocked in the head. They could have a concussion. Their head could not be working right. They could be traumatized. You have psychiatrists and psychologists that can testify about that. Like your mental faculty and capacity could be impacted by a number of things. But what he's saying here, okay, he's continuing like he does. Police never asked her about glaring inconsistencies, never sought a deeper understanding of still undisclosed evidence. A blood-covered jacket? I didn't know about that. Y'all know about that? A bracelet found on the floor of the spare downstairs bedroom. And shoes matching a tread pattern found in blood near her room. Near her room? Wasn't she on the first floor? I thought nobody went down there. He says, he says, to this day, police have not once indicated in the files, so they may have it in their head. That's why we write supplements, to get it out of the head into the record. They've never once indicated that they doubted any part of her story. He says, this is him saying it, not them, they have never considered her a person of interest. She has never been implicated in or charged with the crimes. Now, is he accusing her? No, I don't think he is. I think he's being a good cop. And how many times, you guys know, you watch all these stories, you always look at the people closest. You always look at the people that were there. It's just police 101. You have to rule people out. I mentioned Nancy. You have to rule the family. You have to rule out who last saw these people. You have to look at motive. You have to look at this stuff. Now, going to Turvey, what Turvey said. revenge, anger, okay, is somebody, and I mean, there's a different thing we could talk about, people hating their mom or people hating the women in general because violence against women because something happened in the past. But this is like personal. Like you wronged me. Personal. Not general. So, and just because he's saying it doesn't mean they didn't think it. Doesn't mean they didn't do it, but they didn't memorialize it. And the question is, do they have to put that in the report? Do they have to put that in the report? Every thought that goes through the cop's head during the investigation, the detectives especially, like all that doesn't go in the report. Kind of like we talked about Nunez with when he's responding to the initial scene that he thinks we just have a drunk person. He's not at that point looking for what evidence shows what weapon was used. Because he's not focused on that at that point. So, depending on what time these interviews were made and all this stuff, like, I would hope that they would have gone through the checklist in their head. Okay, we eliminated this person. We eliminated, who had the means, motive, and opportunity. We eliminated this person. We eliminated that person. But I'm not sure that it has to be in the report. Not sure. Okay. And he says only 2 people know what happened inside 1122 King Road between 4 o'clock that Sunday morning when the murders occurred and Funk's call to 911. He says it's important, it seems to him, that these stories add up. Yes. But he doesn't mention shock and trauma and alcohol and all this stuff. And again, we're going to get into the detail. I only want to hear and comment on what she actually said. At this point, I don't need to listen to the summary. Okay? So we're going to skip that part. But read the book if you want to get into all that. It's a bunch of pages, but I want to hear it. I want to hear it from the horse's mouth. All right, we're going to move on. All right, we moved on to chapter 7, and chapter 7 is entitled Rage Kill, Lurid Dreams, and Detective Gooch. Now, Christopher Whitcomb, the author, opens this up by saying much of what He wants to educate us on the legal system. We've talked, you and I have talked to you a little bit about that. He says much of what the public knew about the case prior to the change of plea hearing came from court filings. Okay? Because you have to bring these things into court, right? There's this whole, humongous pile of evidence, and then the defense attorney primarily has to determine what to file, what they're going to challenge. The prosecution and the police have come up with a story, their theory, their version, their perspective of what happened that they're going to tell the jury. Remember, we talked about our Netflix shows or whatever. Every director does it a little differently. Their perspective, their focus on the show is different. They're actors. Okay. Is it a drama? Is it a comedy? Okay. So the prosecution has their piece. The defense has their other piece. And in it, the defense, like plotting a scene. Are we going to go to the house? Are we going to do this? What about this? What about this? What about this? So it comes through filings to get things. The defense is getting rid of evidence, getting rid of anything that's going to be bad for their client. And many times showing who might have done it. Some other dude did it. And invoking protections under the Constitution. And again, I think the biggest misnomer when I talk to folks is that it is not about right or wrong. I mean, ultimately it is. But in there with the constitutional protections and the way that the court and stuff is presented, it's like a TV show. It's like a scripted TV show. There you go. Okay. So that's the way it is. So he says that she and Taylor, the defense, filed many of motions. Supplemental disclosure, that's stuff that they're going to introduce. Change of venue, saying that he can't get a fair trial here because the jury's going to be tainted. Exclusion of evidence, okay, that's what I told you, trying to get rid of pieces of things. And he says prohibition of certain language, including the phrase bushy eyebrows. Now, I remember hearing that in the news. And all mentions of psychopath. Okay, I didn't hear that one, but I did hear the bushy eyebrows. So he wants to talk about terms, right? Just like here's your, case terminology 101. He talks about voir dire, which is the jury selection. They get evaluated, okay? Then he talks about, he says, and this is his words, we have to consider that all Americans, including those accused of being monsters, enjoy certain protections under the Constitution. Yes. And while we don't like it when we have been the victim of violence or something happening to us, if the shoe were on the other foot and we were falsely accused, we would want every protection under the law, even if we were accused. Everybody gets treated the same. So he says here, the Supreme Court has ironed out a great number of disagreements. Fourth Amendment, search and seizure. Fifth Amendment, incrimination. Sixth Amendment, due process. 8th, 14th, okay, blah, 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 blah. He says the standard for guilt is proof beyond a reasonable doubt. Probable cause gets the arrest. Beyond a reasonable doubt is the end of the story, okay? It's like watching a movie, to use the analogy. Sometimes, or reading a book, you can't even get into it because you're like, this is so horrible, and you turn it off. Sometimes you watch it all the way through and you're like, that was a waste of my time. And then sometimes you're on your seat like, oh, wow, wow, wow. Kind of like we're reading this book, right? Oh my gosh. And then you get to the end and you're like, dang, that was great, right? And you followed along and you got to the conclusion that the author or the director wanted you to get to. The prosecution is putting on their show. They want you to get to their conclusion, that it was the defendant. Here's how he or she did it. And this is why. Sometimes motive, don't really need motive, but it's helpful because it makes sense to us. Here's why. Same thing with the defense. Wasn't my guy. That's not what happened. And that thing doesn't show that. You're wrong. Okay? That's what it is. So he says, fairness and impartiality should be the objective of every investigation. Yes. Who wants to convict an innocent person? Okay? Now, he says, with this in mind, we've got a death penalty prosecution here. Like that's as serious as it gets. Okay? And I just saw in somewhere, they reinstituted the firing squad. I mean, maybe that's more painless. I don't know. But if that doesn't say anything about being put to death, okay? So, he says, we've got this death penalty prosecution where he changed his plea to guilty after 2.5 years of denying it. Well, oh, come on. Of course he's going to deny it. Nobody. Is there a case? I don't know. Is there a case where somebody has walked in for first appearance after being arrested and said, Your Honor, I did it? Or at the first trial meeting, has somebody said, I want to change my plea? Have they immediately said, I want to change my plea? I don't know. Okay. So he describes us, the readers, the people that have watched this case. He says, people seem split between Bill Thompson, remember, he's the prosecutor. Remember, we read that before Bryan took the plea, the judge was asking Bryan questions and he read that document. And Mr. Whitcomb was like, that ain't even getting to the half of it, right? So Whitcomb is saying that half of the people, because he says split, half of the people, well, we won't say half, but some people are like, yep, that's what happened. Yep. According to the prosecution. Yep. Good, guilty, boom. And other people are outraged by the disclosures, which Whitcomb says seem to foster doubt. And these are some of the things that we're talking about, right? He says, yes, the families have gained some measure of closure, but it could be insufficient. And we've heard some of that, right? So he says, he's going on here. Let me put this. Hold on. So he's talking about justice being blind. We also have to understand it's tedious, complicated, and prone to error. Yes, he says, as we have seen with the knife sheath, experts cannot agree on what should be obvious facts, such as where evidence was found, let alone who handled it on the way to the lab. Okay, so at the first part of that sentence, I was going to say, well, experts are typically never going to agree in a court case because the attorney is going to hire somebody, even though they're supposed to be independent. If it doesn't help the case, they're probably not going to introduce it. Okay, so experts are there. Okay, it's just like you got the prosecutor and you got the defense attorney. This is the story here. This is the story there. Now, he goes on to say, maybe this is the reason that we have the protections, the constitutional protections, because it's going to be a he said, she said, or he said, or she said, she said. And he said these procedures, okay, we're talking about the constitutional protections, the rules of evidence, all this stuff that may seem cumbersome in a 3-month trial, all the lawyering, objection, this, that, sidebar, jury selection, all that stuff. Like, we just want to get to the meat. Okay, like, let's go. Let's hear it. He says they may seem cumbersome, but they protect us from vigilantes incited to lynchings, towards lynchings, right? So he says, no matter where one stands, the objective has to be the truth, and the truth has to be objective. If we believe in the system, we have to honor its rules. And yes, I'm all about justice and the truth. Was I a cop? Absolutely. Have I seen that cops have done bad things? Yes. Do I like it? No. Have I seen defense attorneys do bad things? Yes. Have I seen prosecutors do bad things? Yes. Have I seen people do bad things? Yes. Have I seen miscarriage of justice? Yes. And my job, when I come in that expert role, I am independent. I don't want to be told anything. I'm going to make my determination how I'm going to make my determination, and that's it. I'm not going to be swayed. But what Whitcomb is talking about here, like with the knife sheath, the thing on the bed, if the picture is in the bed, the picture's in the bed. Like, if it's in the bed, it's in the bed. If it's on the floor, it's on the floor. Like, the picture's there. Now, what's helpful is, was there a picture before the picture with it on the floor? So, could it have been in the bed and then the house vibrated or somebody moved somebody or whatever happened? Remember, it said it was lightly under her thigh. And what happens? Have you ever sat down on the couch and something goes flying off? Or, right? Okay, you know what I'm saying. Whoop! And the thing goes whoop! So, side effects are free. Or sound effects are free. Okay, so do we have a picture in the beginning? And I'm not saying that what he's saying is not true, but we have to look at like what he's saying. It's a fact. Yes, there's a fact. There's a fact. I haven't seen it, but he's saying, I'm going to trust him as a cop, right? Whatever. He's writing this. I would hope he's not going to put his professional reputation out there, but he's saying, maybe you guys have seen it, that there's a picture out there that shows the sheath on the floor. Okay, what time and date was that? Is there a picture before that shows that it was precariously on the bed and it fell down? There could be. There could be. Maybe there's a picture of it being on the bed under the thigh. And in between the 12 hours, remember it was like 12 hours for Tolbert to come and do the crime scene, maybe it fell. Maybe it fell. Now the whole blood soaking in and all that, like, okay, so I was going to say the truth is situational, but I don't like that language, but it kind of is. At one moment in time, the truth is the truth. Okay? It has to be captured. That's why the body-worn camera and the digital evidence and all this stuff, all right, is so important. Okay. He's going to talk about more terms. Accused, we know what that is. Due process, okay? That means that you get the rights that are afforded to you. Guilty, we know, right? So you're either decided guilty, someone tells you you're guilty, meaning the jury or the judge, or you plead it. You accept that term to describe yourself and you admit to it, okay? Indicting, grand jury. They pull all the people together, they present evidence, the grand jury makes the decision. Grand jury, trial jury. Prosecutor, we know what that is. Prosecutor, state attorney, district attorney. Admissible evidence. Now that's where there could be things in a case that the prosecutor wants to put. So when you have something happen, the police go out and get the things, the evidence, all the stuff. They talk to the people, the witness interviews, the body-worn camera, the whole mound of stuff. And the case goes to the prosecution, either through the agency requesting a warrant and the person gets arrested, or they get indicted, or the police making an arrest, and then the prosecution reviews it. So at some point, the prosecution is going to say, because Brady, remember Brady, they're going to say, give me all that you got. And it's going to go over there. Okay. So now the prosecutor has to review it. Prosecutor has to review it because they're governed by ethical guidelines. And they have to make sure that they have a good case. That they're not just prosecuting an innocent person and all that stuff. That it meets the elements of the crime. Like, they have duties. Okay, it's not just a free-for-all. Again, I'm not a lawyer. But the prosecutor then decides what they're going to use when they call their case. They're going to decide, going back to our Netflix analogy, what scenes they're going to have in their movie. Okay, what actors, what props. Okay, what actors, what witnesses are going to tell the story, what props they're going to bring into the case, and how they're going to do it. And sometimes the judge says, no. And basically, the defense does the same thing, and they argue and back and forth, and I call it, like dad, the judge says, sometimes mom or dad says, no, we're doing it this way, we're doing it this way. And in between, there's rules of court and things like that. Constitutional protections, okay? Like, for instance, the defense saying, the chain of custody on that thing, that's baloney, and we're not having it, and it's a violation of this, that, and the other. And then the judge makes the decision, and it's either in or out, okay? You hear, after cases are over, they pull the jury, and the jury's like, I wish I would have heard that. If I would have known that, I would have done X, Y, and Z. So that's how that happens. Not everything, like they just don't throw all that stuff on the jurors and say, have fun, figure it out. They don't. It's presented, okay, as the story unfolds. So there's admissible evidence, material and circumstantial. So material and then circumstances, due to the circumstances. We got the search warrants. He was arrested. He was read Miranda. We talked about Miranda here from Phoenix. You have the right to remain silent. He got a public defender. Okay, that's a protection, just like in the United States. In the United States, you get a prosecutor. You get a defendant if you can't afford one. And then he was held without bond because he was seen by the judge as a danger to society, even though he was innocent. Until he changed his plea. And then he got sentenced and he's going to prison. Jail is jail, under a year usually. Prison is prison, over a year. And he got no parole, no possibility of parole. And he's going on talking about the judge ruling on motions, right? Because you have to, the motion is like asking permission, like complaining in a sense. Your Honor, this is BS. We don't agree with this. This is not fair. Think about a child. This is not fair, Your Honor. And no. And then the state says, but it is. And then the judge has to be, like I said, like the parent and make the decision. He makes a big point here about stipulate. And a stipulation is basically an agreement. And I mentioned stipulation. I don't know where he's going with this, but he mentioned stipulation. I mentioned stipulation with this tip, I believe. Remember, the FBI, and I might have done it. I don't know if I did it here because I don't think we've gotten to that yet, but I did it in the part where I was going through the challenge for the forensic genetic genealogy. And both parties stipulated that it was a tip. For whatever that, I don't agree with that at all, but whatever. They both agreed that it was a tip. Okay, so a stipulation means we're going to present it this way. We're going to have this, we're not going to have this. We agree. It's kind of like parents agreeing on a parenting plan. Okay, for lack of a better analogy. He says that most lawyers don't agree on anything. You see them objection, fighting in court. Now, let me put this in here. Okay, so now we're talking about stipulating, agreeing. Whitcomb is making this presentation that both sides stipulated the facts. They're agreeing to the presentation that Kaylee Goncalves, Madison Mogen, Ethan Chapin, and Zaina Cornado were viciously murdered November 13, 2022. They agree on that, yeah? In a 3-story house at 1122 King Road, Moscow, Idaho. And now he says, Whitcomb and us, we can all now stipulate that on July 2nd, 2025, Bryan pled guilty because we saw it happen, okay? So we don't have to agree on it. In fact, it happened, right? And shortly after was sentenced by Judge Hippler to life in prison without the possibility of parole. Now, he's saying that those who have followed the case can stipulate that Latah County Prosecuting Attorney's Office believes Kohberger left DNA on a K-bar knife sheath at the scene, used the 2017 Hyundai Elantra, and posed for a thumbs-up selfie at approximately 9:47 a.m. while dressed in a hoodie. Okay? So he says, he also adds, because he puts the zinger in there, we can stipulate that for a time, Ann Taylor disagreed. So all the way down there, okay, so we've got the crime that happened, who were the victims, and where it happened. Okay, that's the basis. Kaylee, Madison, Ethan, Zaina, November 13th at 1122 King Road, Moscow. It doesn't say a time, does it? It doesn't say anything. Now we know, because it happened. I mean, we know that the homicide happened because the people died, and we know where it happened, okay? So that's a fact. I don't know if you need to stipulate on that, okay? It is what it is. Now, but they are moving forward with the case, okay? Now, on July 2nd, Bryan pled guilty. He got sentenced. And we know because the state attorney read it, the Latah County prosecutor read it about the K-bar, knife sheath, the car, and all that stuff. What Whitcomb is saying here is that for a time, Ann Taylor disagreed, okay? Because she was filing pleadings, and she might still disagree. She might still disagree with the facts as presented by the state. She might. But Bryan agreed to them because he pled. Ann might still disagree. We might disagree. Okay? But Bryan pled. So he made a deal. He agreed to plead guilty to those facts. Okay? Whitcomb is going on here saying that he's saying that we can now, because we've read his book, stipulate or agree that Paulette Sutton believed certain things that Brent Turvey did not. You may not, we may not. Whitcomb is saying we could, okay? Because he feels he's presented that what Paulette Sutton thought and what Brent Turvey thought were different, okay? I would suggest reading the things for yourself, okay? He's also saying that what Sutton thought the bloodstains were in the common area may have been diluted with saliva from wounds inflicted upon Zena's nose and mouth. That's one version, one perspective. He says Turvey found that absurd, okay? He says, again, Officer Nunez's initial report differs from what his body camera shows. Again, we would have to watch the body camera footage and put it side by side. We haven't. I haven't. He says, because Ethan did not kill himself and Hunter did not show Nunez the steak knife or say that he placed it on the table. Okay? He's pointing out these discrepancies. He's saying if you follow what he's presented in this book, he's hoping that you can agree on that no one, including Detective Talbot, seems to have noticed the K-bar sheath in Maddie's bed until 3 weeks after the crimes, when a December 6th ISP report claimed it did. He's saying we can agree, if you follow his presentation, his theory, that 4 statements to the police, Dylan Mortensen, seem to offer different information than what happened in the 8 hours between the crimes and the call to 911. Now, we haven't gone into the exact detail. We're not going to make an inference or an assumption based on paraphrasing. I want to hear it from the horse's mouth, okay? Now he's talking about in limine. And it talks about, in these court cases, motions in limine. And he references the Latin term saying at the threshold. So, motions in limine are things that need to be determined before the trial, okay? Whitcomb goes on. The criminal history of a defendant, offers of settlement, unsuccessful plea deals. The goal is to prevent unfairly prejudicial information from becoming guilt by insinuation, okay? What is going to be entered and what is not. Some of that. And Whitcomb says, that only seems fair until you consider that when the penalty is death, attorneys will argue the most picayune, again, he's got a big word there, assertions desperate to make their case. It is up to the judge to sort things fairly. Okay, this is where I'm talking about like the dad. Okay, the dad in the case. So he goes on to say that Judge Hippler had to play referee, if we want to call it that, for 30 months between January 23rd, 2023 and July 2025, refereeing all these. He did this, she did that, he did that, okay? Meaning the attorneys, no, we can't have this, I don't want this, you can't do this, the rules say this is bad, this is good, okay? And now he's telling us that he thinks some of them were silly, such as motion in limine 4, to prohibit the state from referring to Kohberger as a psychopath. Now, where is he going with this? Why is this important? Why is he devoting a whole chapter to this? Is he leaning towards ineffectiveness of counsel? I'm getting a whiff of that, okay? He says, while this game of sticks and stones, like I said, like children, dad, he says, while this game of sticks and stones may seem petty, defense attorneys get quite serious about the manner in which their clients are described. Rightly so. Especially with spectrum disorders who tend to stare blankly at the wall. Yeah, because, people are, I don't know what, making fun of him or thinking the wrong, I don't know. He says, this is Whitcomb, Kohberger's appearance has been the subject of widespread speculation, but the prosecution agreed not to take advantage. Now, sometimes they will. Like you've seen a TV show where they say, ladies and gentlemen of the jury, look, the defendant has not shed a tear. Right? Things of that nature. He also is bringing up motion in limine 6. Okay, these are, again, things that have to get sorted out before they move to trial. And this was submitted by Bicca Barlow. Okay, now I think we heard her name in the genetic genealogy, and she is part of Ann Taylor's office. Okay, so she's not alone, maybe, I don't know. In hopes of prohibiting an ISP laboratory expert named Riley Nowen for referring to touch DNA. And I believe I did a whole video on that. It's not part of this YouTube channel, but I can find it. And this was descriptive language on what is considered touch DNA and what word you should use for DNA that rubs off. Touch DNA versus transfer DNA. Okay? Now, he says that this is about Kohberger's DNA that had been found on the K-bar sheath. Okay? So let me put this. He says, unlike motion 4 about the words, this one is very important. So let me put that here. All right. So, what they argued here, these are Barlow's words. Both the term touch or contact DNA or any opinion regarding how DNA end up on an item is misleading. Barlow wrote in a document filed February 24, 2025. In that it assumes facts that must be proven would be confusing to the jury and waste substantial time in debunking the testimony of an expert that is outside the purview of the field of expertise and qualifications. Not sure who they're talking about there. Oh, they're talking about Nowen. So I think what happened, if I remember correctly, and don't hold me to this, Raylan was a lab tech or somebody that worked for the lab, and she was using a common word like we call a tissue a Kleenex, but it may not be Kleenex brand. Overly generalized, but you'll get the point. And so touch, transfer, contact, that DNA that got on something from contacting with something else, okay, they could not decide on the words, and she randomly used a common word, like calling a tissue that's not a Kleenex. I can't think of a better way to explain it. And so they were talking about if it's touch DNA, they didn't like the word touch because that meant it had to be touched or contacted, as opposed to some other way, flying through the air, rubbing off, or something, meaning intentional. If we think about touch or contact, that's intentional. Okay? Let's just say, okay, weird example. He contacted me versus butt dial. The phone actually, it just happened because the screen was left open and something hit it and it dialed it. You didn't intentionally mean to place that call. You didn't intentionally contact somebody, okay? So that's where they were going with that. Did, whether it's the knife sheath or whatever they're talking about, did he intentionally have it in his hand versus, oops, something rubbed up against it. It fell down, it hit something else. All kinds of ways we can talk about DNA transfer or whatever, okay? So, what he's referencing here is that Barlow's objection to the words were filed long before Dr. Turvey discovered the chain of custody issues, which this is Whitcomb says, might have led to exclusion of the sheath and DNA found upon it. Okay. I'm formulating where he's going here. I'm thinking, and I haven't read the next paragraph, I'm thinking with this, it was on the bed, it wasn't on the bed, it was on the floor, it was placed on the bed. Could somebody say that, that wouldn't be right either, because then the DNA would have been somewhere else in the house, and that's not beneficial to the defendant. Okay, squash that. Okay. He goes on, furthermore, the opinions of this expert have not been disclosed to Mr. Kohberger, Barlow wrote. This must have been Miss Nowlin. As set forth below, the how and when DNA arrives on an object cannot be scientifically determined. Yeah, so that's the thing. So if there's an item, somewhere, and your DNA turns up on it, is it because you actually grabbed it, or is it because you grabbed something that somebody else had touched and grabbed, and it got transferred through the people? Okay, easy way to kind of explain that. So they were saying that it's a poor, not the proper subject of expert testimony. And I don't believe that was her expertise. We talk about Dauber and Fry challenges. And she said that this language is confusing and is barred by Rules 402 and 403, as well as due process. So Rule 402 and Rule 403 would be the rules of criminal procedure, valid in that jurisdiction, and due process, Constitution, and it's prejudicial. Okay? So he says, how people might wonder how it's unfairly prejudicial to suggest that a person could transfer DNA to a sheath just by touching it. Are there other questions too? So he says, why is the defense entitled to know a laboratory expert's opinion prior to them taking a stand? What makes one person an expert and other experts refute them? This is what the hell are Rules 402, 403, and why would a jury care? Okay. So those are all the rules. Like all this is, are we going to get to show it? Are we not going to get to show it? So the answer of all this hoopla, he says, he's quoting her, current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, i.e. direct or indirect transfer. And I answered this question. Folks were asking me this in a podcast episode discussion about Nancy Guthrie. And somebody asked me, which is a very good question. I'm not a biologist, but my understanding is they can't. But they said, can you tell when DNA, like just looking at the DNA, can you tell when the DNA got on the object? Wouldn't that be great to know? Oh, it's 4 years old. That would be awesome. Okay. Because I have said, and I'm going to circle back around this. When I first heard about the K-bar sheath, I didn't know it. We kept hearing the snap, 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 snap. I'm like, well, what part of the snap? The top part of the snap? The under part of the snap? The raised part of the snap? Like just the snap? I said, well, what if it was hanging in the Big Five store and if it was the top of the snap and he just walked down the aisle and brushed against it? Like a speck? Like that's it? Think about how many things that we brush up against, touch, and do all this stuff. We pick up something in the store, we look at it, and we put it back. A can of peas, for example. And oh my God, somebody gets murdered in the grocery store. And they pick up the can of peas. It was in the pea aisle. And then they're like, they were there. Okay? Right? So good and bad. Okay? We wanted to prosecute people, but not when we're not guilty. Okay? So what's the context? Okay, so let's say I pick up the can of peas and I say, no, don't want peas. And then the killer picks up the peas right after I picked up the peas. Now we have potentially a mixture of me and the killer on the peas. Who's the killer? Okay, then the killer takes it and touches the front door of the house, wherever the killing happened. Let's say it doesn't happen in the grocery store. They touch the front door of the house. My DNA is on the front door of the house. And I may be the primary contributor, the big portion, because I held the peas longer, because I couldn't decide about the peas. And the killer picked it up and said, wrong brand, puts it down. I'm just giving you examples. But then later on, he goes and touches the door and he killed someone. And I'm on the door because I touched the peas. That's direct or indirect transfer. That's indirect. Okay? So, going back to Nancy. Can we tell when it was there? No, we can't. Not yet. There's a lot of stuff we can tell. It's not like soil. I think we talked a little bit about soil and the pollen and things like that. It depends on what's there. I would love to know, because there's debris in DNA, there's other stuff, like hairs and different things. That would be great. But like soil, we can tell where the soil is, like the pollen. Remember, we looked at the trees. East Coast trees, not West Coast trees. So that would be kind of cool. And I'm sure it's coming with different things. Maybe we've got some molecular exposure. That would be kind of cool, wouldn't it? Changes to the cellular material. That would be awesome. Okay, but we don't have it. Like right now, it's just the peas. Okay. So let me put this part up. So when they argued, they got all the wording sorted out. Bicca writes what I told you. Current technology cannot conclusively answer of when it was deposited or by what mechanism. Okay. indirect or direct transfer, intentional or P's. We can call it P's, okay? But she states based on the report, she states it is possible the DNA detected on M2022-4843 item 1.1 resulted from secondary transfer. It's possible. P's. However, based on Nowlin's training and experience, it is her opinion. She's referring to Nowlin's opinion, the lab tech, given the quantity of DNA detected, how much was there, and given that the profile was single source, it is more likely the result of a direct transfer, meaning one time, not P's. Okay? Then he talks about that Barlow mentions CODIS, but not the fact that DNA swabbed from the sheath failed to meet their minimum requirements for what is known as YSTR submission by a lot. She did, however, make a point to cite numerous academic journals, including one that claimed it is impossible to determine from quantity alone how Kohberger's DNA might have ended up on a sheath. Now, that's important. Let me put that there because I want to talk about that one. Okay, so we have this statement up at the top that Bicca on the defense side and Nowlin on the state side appear to say that it could have either come from secondary transfer, but that Nowlin says, given the quantity, read the words here, given the quantity, and that it is single source, remember it was 10 cells, wasn't it? It's likely the result of a direct transfer. Now, it didn't meet the minimum requirements for YSTR submission by a lot. And I don't know exactly what those specifications are, but it's quantity of YSTR, I believe. Like it's a quantity. It's a quantity quality issue. So if, I'm just asking the question, if in Nowlin's opinion, the quantity was so good, and I'm being sarcastic here, it was so good, there was such a preponderance of the quantity that, and it was single source, that it was more likely direct transfer, then why wasn't it enough for CODIS? It's a good question. And he says, Whitcomb says by a lot. Okay, remember we heard 10 cells. All right. And then according to, this is, Whitcomb says she did, Barlow, the defense witness, defense expert, make a point to cite numerous academic journals, including one that claimed, remember, watch his words here, it is impossible to determine from quantity alone how Kohberger's DNA might have ended up on the sheath. Are these not in direct contradiction with each other? Do you see that? Okay. Whoops, hold on. Okay. So he cites then a book on DNA transfer, or no, she does, from G. Meakin and A. Jamieson from 2013. I guess she's a geneticist lawyer, so her specialty is in biology, genetic biology, and law. And they're talking about DNA cannot be attributed to an identifiable body fluid. That comes from the book. Let's see. The authors rejected the term touch DNA as misleading, as such a term infers that the DNA recovered from a surface got there via that surface being touched, rather than rubbing on it or whatever. Okay, that, I don't know, that's like whatever. Okay, so it seems we have a contradiction here. And did that go further? We don't know. Okay, I'm going to end this one here, and I will see you on the next one. Thanks for supporting and watching, and put your questions below.